Good morning. Happy Saturday. This is a constitutional law lesson for a constitutional law scholar who's been studying the Constitution for 20 years and has zero knowledge of it, and who's managed to lose every case that he has taken to completion in the last year. Apparently, he's only been filing cases for a year, but, I, he's new to this, but has been studying constitutional law for 20 years, whatever. I have had a very adamant person in my comment section who requests that I not, in quotes, help Chile by making these videos. And I decline that offer. I thank you for the comment. But by helping Chile, if Chile is able to understand and willing to understand, maybe he won't file frivolous lawsuits and frivolous petitions. And maybe he will be able to better judge when he should or should not file a lawsuit. For example, he's going to lose the hard way if he files a lawsuit against the judge in the recent harassment protection order proceeding because he is 100% guaranteed going to lose. Period. End of story. I will bet $10,000 that he will lose. So if you could show me the money, put it up, then we've got a bet. I'll only take one bet though, because my wife would probably kill me if I bet more than $10,000. Anyway, this is, for those of you who aren't aware, the 14th Amendment to the United States Constitution, Section 1. It is analogous to the Fifth Amendment due process requirement. It says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The Fifth Amendment applies to the federal government. The 14th Amendment applies to the states. They can't take your life, your liberty, or your property without due process of law. A restraining order is a deprivation of liberty. Harassment protection order is a restraining order. They are preventing you from doing something. It is a deprivation of liberty. So they have to give you due process of law. What is due process of law? This is Cleveland Board of Education versus Loudermill, a United States Supreme Court case from 1985, 470 U.S. 532. It didn't make the trifold, but I think it's pretty important nonetheless. The essential requirements of due process, and that all the respondents seek or the Court of Appeals required, are notice and an opportunity to respond. Sometimes stated notice and an opportunity to be heard, but here the court is saying notice and an opportunity to respond. The opportunity to present reasons, whether in person or in writing, why proposed action should not be taken is a fundamental due process requirement. A tenured public employee is entitled to oral or written notice of the charges against him, an explanation of the employer's evidence, and an opportunity to present his side of the story. This is analogous to this is a administrative action, but it also applies in civil actions where the state is going to take action against you. And if you think it's Chile taking an action, it's not. It's the state. The state would be issuing a harassment protection order. The judge is issuing an order. It's the state issuing an order. Chile is requesting the state issue an order, and the state would be issuing an order. And that order would be the state depriving you of a liberty interest. So they have to give you due process. They have to give you notice and an opportunity to respond. Well, they have provided means for notice. This is the Rules of Civil Procedure for Massachusetts, Rule 8. A pleading which sets forth a claim for relief, whether an original claim, counterclaim, cross-claim, or third-party claim, shall contain 1. A short and plain statement of the claim showing that the pleader is entitled to relief, and 2. A demand for judgment for the relief to which he deems himself to be entitled. So you need a short and plain statement of the claim showing that the pleader is entitled to relief. What does that really mean? Well, this is Rule 2. These are the reporter's notes. They're referencing a Ninth Circuit district court case. I don't know why, but they appear to believe it applies. A plaintiff need only plead those facts necessary to show that he is entitled to a relief which the law recognizes. So it has to have a short and plain statement of the claim showing the pleader is entitled to relief. And that has to plead those facts necessary to show that he's entitled to that relief. So he has to plead facts necessary to show that he's entitled to that relief. Now, if you remember, 258E requires a showing of harassment. So he has to plead facts showing that he's been harassed, as defined in General Laws, Chapter 258E, subsection 1, or section 1. So, another thing that we need to be aware of, this is in Massachusetts Guide to Evidence, Article 4, Relevancy and its Limits, Section 401. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and that fact is of consequence in determining the action. Now, what is the action? The action is a claim for relief for a harassment prevention order. Chile has to show facts, relevant facts to the harassment prevention order to show that Kate and or Josh harassed Chile. And by by the definition provided in Chapter 258E, Section 1, it has to show that there was 3 or more instances of harassment by the definition, or that the criminal action of stalking or the criminal action of criminal harassment had taken place. So everything that he was going to put forward, all the evidence that he was going to put forward, had to be relevant to him being harassed pursuant to Chapter 258E, Section 1. Had to be relevant to him being harassed. Now, he did not allege that there were witnesses to these various actions, and even if he had alleged there were witnesses to these various actions, the video evidence themselves would be a better witness to it, and he did not put those forward. So everything had to be relevant to that harassment of him. Now, this is a Massachusetts Appellate Court decision from February of 2015. FAP, I love the name, versus Jess, FAP versus JES. And in footnote 14, harassment orders under General Law Chapter 258E were intended to protect victims who could not legally seek protection under General Law Chapter 209A. Quoting Senni versus Mori and O'Brien versus Borowski, as the court noted in both cases, and those are both Massachusetts Supreme Court cases. As the court noted in both cases, the procedures under those two statutes are very similar. As a result, we see no reason why the guidelines for judicial practice abuse prevention proceedings should not apply equally in harassment order proceedings, absent some issue particular to harassment orders. These are the guidelines for judicial practice abuse prevention proceedings, and this is conduct of hearings after notice when both parties appear. So this is the conduct of not the ex parte initial request for a temporary harassment prevention order pending the hearing. This is at the hearing. So this is the hearing that we went over in my last video where Kate and Josh were present. The hearing after notice at which both parties appear is an adversarial proceeding in which both parties must be allowed to present evidence. For those of you who don't understand, testimonial evidence, i.e. a person saying what happened, is evidence. And it is the predominant evidence that is used in trials. Most evidence is adduced in a trial through testimony of witnesses, and parties may be witnesses. The plaintiff bears the burden of establishing abuse by a preponderance of the credible evidence. The court should ensure safety issues, yada, yada. Before the hearing, the clerk's office should examine the warrant management system, provide the court with active or recent prior related abuse prevention orders in that court involving the parties. The probation department should provide the court with criminal activity record information for both parties and the affidavits from any prior harassment prevention orders, as well as dangerousness findings that issued after August of 2014. The judge should also ask both parties whether there are any outstanding orders from any court involving the same parties. If the court becomes aware of information about recent or active or recent criminal cases involving crimes of abuse against either the plaintiff or defendant, the judge may request those cases be brought into the courtroom. Both parties have a general right to cross-examine witnesses, but the judge should not. The judge should not permit cross-examination to be used for harassment or intimidation or for discovery purposes. Each side must be given a meaningful opportunity to challenge the other's evidence. In some circumstances, it is appropriate for the judge to remind the parties of their rights under the Fifth Amendment. Both parties should be told the defendant must comply with the terms of the order. In addition, there is 503, rules of evidence. The common law rules of evidence, e.g., those regarding hearsay, authentication, and best evidence, do not apply, subject to the conditions or to the considerations of fundamental fairness. Hearsay is an out-of-court statement offered for the truth of the matter asserted therein. Like, my doctor said I have 5 months to live. That would be hearsay because the doctor's not there to testify to that. Authentication, if you're offering a document, it has to be authenticated or recording or something like that, like the person who made the recording, when the recording was made, a statement from the person who made the recording that it is a true and accurate recording, or a photocopy or things like that. And best evidence rule, having someone testify about a document isn't as good as having the actual document. So saying that, my birth certificate says that I was born on the 4th of July, whatever. Offering the birth certificate itself is the best evidence rule. It's more likely to be accurate than any testimony regarding it. But those do not apply. Those do not apply subject to considerations of fundamental fairness. Now, a consideration of fundamental fairness would be like if the plaintiff had offered an affidavit in support of his complaint. The plaintiff says X, Y, and Z happened. That is hearsay. If the plaintiff, however, says Bob said in his affidavit, Bob said X, Y, and Z happened. Well, Bob's not there. And the court is going to have to consider whether or not it's fair for that to be considered, for that Bob said evidence to be considered. Now, they're both hearsay. I guess technically one's double hearsay. But the court can consider whether it's fair. You'll get, because 209A is targeted more for domestic violence prevention orders, which is what we would call them in California. It's more designed for domestic violence situation, family violence. In those cases, you're going to get a lot of hearsay. A lot of the evidence is going to come in hearsay. So just remember that. They don't apply subject to considerations of fundamental fairness. And then the standard and burden of proof. The standard of proof in these hearings is preponderance of the evidence. The plaintiff has a burden of proof at both the ex parte hearing and any subsequent hearing to further extend the order. Both sides have a right to introduce evidence. So now this part doesn't apply. This part says the fundamental inquiry in a 209A is whether the defendant caused harm. It's a different standard. The appropriate inquiry when considering an initial order after notice in the 258E action is whether or not there were 3 or more acts of harassment or there was stalking or criminal harassment, the crime of stalking or the crime of criminal harassment. Where credible effects relevant to this inquiry are elicited during the hearing but not included in the affidavit, the judge should add those additional facts on the affidavit in such a way to denote they were added and credited by the judge. This will allow future judges hearing the case to be better informed about the full context of the issuance of the order. Generally, where this is going to be would be if the complaining party has some other actions that they forgot to put in the affidavit or that occurred after the affidavit was initially submitted. So let's say that Chili was having problems with Kate, and after he filed his affidavit, she showed up at his house and he's got a video of her taking a big fat steaming dookie on his front doormat, right? Let's say he has it on video. The court could say, well, this is credible evidence of Kate taking a fat steamer on Chili's front doorstep. And the court could consider that because it relates to harassment. It has to relate to harassment. And specifically, the definition of harassment provided in Chapter 258E, Section 1, specifically harassing Chile. So it would be relevant evidence, it would be credible evidence, and the court could say, yes, this is evidence of continued harassment by Kate because she took a fat steamer on his front doorstep. Now, did Chile have a right to cross-examine Josh and Kate? This is Timothy Silva versus Maria Duarte, and the single justice entered a memorandum of decision in which he concluded that while cross-examination generally should be allowed in this type of action, the judge's refusal to permit it did not create a miscarriage of justice warranting relief, and we affirm the judgment. So the judge denied it in this case. This is a 209A case, but the judge denied it in this case because it did not create a miscarriage of justice. Now, why didn't it create a miscarriage of justice? Because a rehearing would have produced the same result. The judge made his determination based on the larger record concerning the in this case, it was the defendant's conduct and his previous experience with the defendant. And it wasn't an abuse of discretion or prejudicial. The judge in Chile's case, unless it's an abuse of discretion, looked at the allegations that Chile was attempting to make, whatever word salad he was spitting out, and whatever the judge could construe from it. Assuming all those were true, listening to the responses of Josh and Kate, deciding as a matter of credibility that maybe some of those things weren't true, or maybe Josh or Kate offered a better understanding of the word salad that Chile was spewing to the judge. And the judge said, oh, your version makes sense. It won't make any sense to have Chile cross-examine them because Chile can't spit out a straightforward stream of consciousness about the facts, period. He goes on and on about, oh, you have no idea how much they've harassed me. It's just unfathomable how much they harass me. Oh, my Lord and stars, give me my fainting salt and my fainting couch. So that's what he was doing. Now, let's talk a little bit about the right to cross-examine and how the affidavits were, how Chile tried to get extra affidavits in that. Now, remember, none of the allegations that he made about what the affidavits contained were any issues of harassment by Kate or Josh targeting specifically Chile de Castro. He alleged a lot of things about how they got his friend fired, about how they caused consternation to homeowners in New Hampshire, and all sorts of other things, but not about how other people generally harassed him, but nothing about how Kate specifically and Josh specifically harassed Chile. So a defendant has a general right to cross-examine witnesses against him. There may be circumstances in which the judge may deny that right in a 258E hearing, and certainly a judge may limit cross-examination for a good cause in an exercise of discretion. The practice in civil actions, however, is to permit cross-examination, and in the case at bar here, this is Richard Frazado versus Shirley Frazado, which is another Massachusetts Supreme Court case. A defendant or his counsel should be given adequate opportunity to consider any affidavit filed in the proceeding on which the judge intends to rely before being required to elect whether to cross-examine the complainant or any other witness. On the other hand, the rules of evidence need not be followed provided there is fairness in what evidence is admitted and relied on. So evidence has to be fair. The evidence that's admitted and relied on has to be fair. And look at what it says here. The defendant should be given adequate opportunity to consider any affidavit filed in the proceeding. The affidavits that Zane brought in and waved around from the back of the court were not filed in the proceeding. And had Zane filed them, since the trial was currently underway, the defendant would not be given an adequate opportunity to consider them. You can't put someone on the spot. Here's an affidavit, go. I mean, they have to have time to maybe do their own looking into it. Like, oh, this person says they were there. Let me go back and check my video recording to see if I have any recordings of that person here, etc. Now, and also it says on which the judge intends to rely. So it has to be filed in the proceeding for the judge to rely on it. So Chili just screwed up all over the place. So this video is just a little additional help so that Chili understands notice and opportunity to be heard as required by the 14th Amendment, Section 1, that a state shall not deprive any person of life, liberty, or property without due process of law. Thanks for watching. Good luck, Chili, suing the judge. You're going to lose. And have a great day.